Just going to give it a second here and let folks trickle in before we get started. Okay, I'll kick it off. So welcome everyone to our first Federalist Society event of the semester. My name is Paige Scobie, for those of you who don't know me, and I'm the president of the UT Federalist Society chapter. Thanks so much for tuning in. Thank you to Professor Barnett for being here today, and thanks to our VP of Events, Warren Bloom, for his hard work putting this event together. Just a quick plug for the Federalist Society. FedSoc is founded on the principles of the Constitution, freedom, separation of powers, and that it's the duty of the judiciary to say what the law is, not what it should be. Our motto is debate, discuss, decide, and we're one of the most active groups on campus with a speaker event like this one almost every week. Please consider joining us as a member if you haven't already. I will put details in the chat. And with that, I will turn it right over to Warren to introduce today's speaker.
Thanks, Paige. Hi, everyone. Pleasure to have you all back on campus and here with us in Zoom, over in Zoom land for our first event. Rest assured, we'll have, I think, almost all in-person events for the rest of the semester. So enjoy it tonight and come get your Chick-fil-A middays going forward. I'm very excited to introduce our speaker for this evening's event, the topic of which is the original meaning of the 14th Amendment. Professor Randy Barnett, most of you should, I would hope, already be aware who he is, but by way of background for those who are not, he's a constitutional law professor at Georgetown, where he's the director of the Georgetown Center for the Constitution. He graduated from Northwestern University and Harvard Law School. After Harvard, he tried many felony cases as a prosecutor in the Cook County State's Attorney's Office in Chicago. In 2004, he argued the medical marijuana case of Gonzalez versus Raich before the Supreme Court. 8 years later, he was one of the lawyers representing NFIB and its constitutional challenge to the Affordable Care Act in NFIB versus Sebelius. His publications include 12 books, more than 100 articles and reviews, as well as numerous op-eds. And his most recent book, which the name should be a dead giveaway, will be the focus of today's talk, is The Original Meaning of the 14th Amendment, its letter and spirit, which he co-wrote with Evan Bernick. Professor Barnett, thank you so much for joining us. Before turning it over to you, actually, we'll screen a quick video plugging the Originalism Summer Seminar that you and Georgetown Law will be hosting this summer. You'll see the video, but quick summary, especially to all the 1Ls out there. And frankly, to me, I should probably be pulling my application together one of these days. It's designed to be a boot camp for originalist theory. And this summer will feature speakers, some of whom you may have heard of, a couple you may have heard of are Justice Clarence Thomas and Justice Neil Gorsuch. It runs from May 22nd to 27th, pays you $1,000. There's no reason not to pull together an application, but it will be due this Friday, so enough thinking and more doing. So here's the video. Matt, I'm not sure there's audio coming through.
I'm not hearing any audio.
I had a friend who did this last year and really enjoyed it. Just seeing the lineup of speakers started to really attract my attention.
I've really been looking forward to learning more and taking a deeper dive into originalism and just learning all the intricacies of it.
I'd always been interested in originalism as a judicial philosophy, and I really wanted to know kind of the nitty-gritty of what it was as a theory. So that was my hope in this boot camp.
we've decided to try to recruit some of the best law students from around the country to come to Georgetown and be exposed to the cutting-edge, state-of-the-art approach to what originalism is and how it should best be practiced.
I definitely didn't really know what originalism was ahead of time, and just getting to hear from so many different originalism positions, not just one vein of originalism.
But it's way thicker and way more rich than I thought. I mean, there's competing theories of what the actual truest form of originalism is. There's competing theories about, what to do with originalism.
I'm someone who's interested in strategic litigation and appellate litigation. That is particularly why I also want to understand how lawyers and judges can use originalism.
I was interested in how to actually practice it. I mean, theory is one thing, but sometimes there's a disconnect between theory and practice.
Our lunch presentation from Justice Lee was fascinating.
He's talking to us about the use of corpus linguistics, which is kind of using like research databases in order to help determine the original public meaning and usage.
We had practitioners, historians, we had a philosopher of law talk about originalism. So I thought that was very useful to hear all these different perspectives.
Without a doubt, the thing that most excited me about the boot camp was getting to meet the Supreme Court justices. I mean, we get to meet Justice Gorsuch, Justice Thomas, and Justice Alito.
Seeing Supreme Court justices is great. I think I'm still a little bit shaky just from all the excitement going in there.
Hearing about how the Supreme Court works behind the scenes and how the justices interact with each other was really interesting.
We are really looking for people we think are going to be the intellectual and practicing movers and shakers in the future.
I've probably never met such an accomplished group of students.
Part of it's intimidating because there's a really good group of people here.
Many of our students have done judicial clerkships or are going to be doing judicial clerkships, so they will actually be assisting judges in writing opinions, and their knowledge of originalism could come in handy when that happens.
I would like to clerk, and I think all the tools that we're given here will help to enable me to do a good job for my judge.
Understanding how to read the Constitution is a really basic part of being a successful clerk. So having a clear theory of how to interpret the Constitution, I think, will benefit me.
All in all, I feel like I have a much better grounding in what originalism really is, both the theory and the practical application, as well as some of the newer developments. The array of speakers and everything that we had leaves me feeling much more confident in what I do know about originalism, but also inspired to learn more.
Like I said, applications are due Friday, so let's all get together and get those submitted. So happy to kick it over to you now, Professor Barnett. I think you said you have about a 20-minute talk prepared for us, and I'll come back in with some questions, and hopefully some of you listeners will come up with some questions to submit as well. So
great. Well, thanks so much for having me, Warren. Thanks to the UT Federal Society for having me. I wish I could be there in person. I was just watching the video, and Claire Cahill, who had been interviewed twice for that video, went on to be a Supreme Court clerk. She didn't know that when she was interviewed for the video, but she ultimately became a Supreme Court clerk. Anyway, I'll just say a few more words about the summer seminar. First of all, you get a diverse views of originalism, and you don't just rely on me to explain the different flavors of originalism, but we do invite in the leading theorists who propose particular theories of originalism. We have Mike Rappaport on original methods. We have Stephen Sachs from Harvard on original law originalism. Jack Balkin from Yale on living originalism. And this year we're inviting Josh Hammer to come in from Newsweek, just to come in and talk about his common good originalism approach. And in addition to that, you'll hear criticism of originalism. Tom Colby from GW is a published critic of originalist theory and knows a lot. Unlike other critics of originalism, he actually knows a lot about originalism. And so he's actually criticizing the real originalism, not some 30-year-old memory of what originalism might have been at one time. So, and when it comes to visiting the court, our fingers are crossed that the court will be open. It's not open now. It hasn't been open the last couple of years, but if it is open, we're not going to see 3 justices, as Warren mentioned. We'll be just seeing 2, Justice Thomas and Justice Gorsuch. That was a very unusual year that we saw 3 justices. So anyway, I encourage you to apply, and we'll also have, if there's a sufficient demand for it, a Zoom section. In case you can't make it in person, then you could ask to opt for the Zoom section. Okay, Having done the sales pitch on the summer seminar, which is the reason I've been speaking at law schools this January and now February, I'm going to move to the sales pitch for my book, The Original Meaning of the 14th Amendment, its letter and spirit. And again, as Warren mentioned, I have a talk that runs about 18 minutes or so. And then after that, I guess Hill and I have a conversation about it. So let's get into it. Now, imagine you're a visitor from outer space on Earth for the first time, and you read the following in the U.S. Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That would sound pretty important, don't you think? Then imagine finding out that since it was adopted over 150 years ago, the Privileges or Immunities Clause has only been used twice by the Supreme Court to invalidate a state law. In 1999, a majority invoked it to protect the constitutional right to interstate travel. Then, in 2010, it was the sole basis of a concurring opinion by Justice Clarence Thomas, who provided the fifth swing vote to protect an individual right to keep and bear arms from being infringed by a state. In 1873, just 5 years after it was enacted, the clause was all but redacted from the text of the Constitution by the Supreme Court in its 5-4 decision in the slaughterhouse cases. There, the majority limited its scope to the rights, quote, which owe their existence to the federal government, its national character, its constitution, or its laws. Now, lest he be accused of nullifying the clause, Justice Miller provided several examples. My favorite is the right, quote, to demand the care and protection of the federal government over his life, liberty, and property when on the high seas or within the jurisdiction of a foreign government, unquote. As if this was the kind of right that Southern states were depriving formerly enslaved people after their emancipation by the 13th Amendment. Now, what about the right of freedom of speech, press, or assembly protected by the First Amendment from infringement by the federal government? Or the right to keep and bear arms that is protected by the Second Amendment? In the 1876 case of Cruikshank versus United States, the Supreme Court made it clear that these fundamental natural rights enumerated in the Constitution were not protected because they were not created by, they did not, quote, owe their existence to the federal government. Because they are pre-existing natural rights, their protection was left solely to the states, as though these were not the very rights, the equal protection of which was being systematically denied to the freedmen by their own states. In this way, the Supreme Court created a hole in the heart of the 14th Amendment. Eventually, the interpretation of the due process of law and equal protection of the laws clauses was expanded beyond their original meaning to take up some of the resulting void. This is like when you lose a tooth, the adjacent teeth move over to fill part of the gap. But the result is neither perfect nor pretty. In our new book, The Original Meaning of the 14th Amendment, Its Letter and Spirit, Evan Bernick and I explain the original meaning of each of these operative clauses in Section 1, as well as discuss the enforcement powers of Congress created by Section 5. By original meaning, we mean the information that was conveyed by the text of the amendment to a competent speaker of English, such as members of state legislatures who ratified it and other members of the public. Presenting the quantity of evidence that is necessary to establish this meaning, as well as replying to scholars who have reached different conclusions than ours, occupies the bulk of the book. Modern originalists call the activity of identifying the information communicated by the text constitutional interpretation. But in the introduction, we explain why discovering the original meaning of the text is not always enough to tell us how that meaning should be applied in particular cases. Originalist scholars call the separate activity of application constitutional construction. Therefore, we also explain why, to faithfully apply the original meaning of the letter of the text to particular cases, one needs to identify its original spirit. By spirit, we mean the original ends, objects, functions, or purposes of each clause. That is, the original problems these clauses were adopted to address. This is sometimes what is meant when people speak of the intentions of the framers. But the historical inquiry into the publicly known functions or purposes of the various provisions of the Constitution is not, I should stress, an inquiry into the subjective intentions or expectations of its authors. Neither the letter nor the spirit of the 14th Amendment is limited to how its framers would have expected it to be applied in particular cases. An accurate account of the original spirit of the amendment enables judges and other constitutional actors to faithfully adhere to the letter of the amendment when applying it to particular cases. To highlight that interpretation and construction are two distinct activities, we present the evidence of the letter and the evidence of the spirit of the text in separate chapters of the book, and they're labeled. Well, so what was the original meaning of Section 1 of the 14th Amendment? To understand its meaning, you need to start with the citizenship clause that begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The Privileges or Immunities Clause that immediately follows this sentence protects the rights that are fundamental to what we in the book call Republican citizenship, a concept of citizenship that is grounded in natural rights and civil equality. In several chapters, we chronicle the intellectual origins of this concept of national citizenship in the writings of constitutional abolitionists such as Lysander Spooner and Joel Tiffany. We then explain how a similar but more moderate view was then adopted by the Republican Party. To combat a virulent tide of white supremacy in congressional Republicans eventually enshrined their concept of national citizenship in the Constitution by adopting the 14th Amendment, which was not limited in its application to the South, hence the label Republican citizenship. What are the privileges or citizenship to which the letter of the clause refers? They are the fundamental personal guarantee identified in the text of the Constitution, such as the freedom of speech and rights that were enumerated in the Civil Rights of 1866. But you can also get a little more fundamental and say that the privileges or immunities of citizens are what we call civil rights. It's what they called civil rights. What are civil rights? Civil rights are the rights you get when you leave the state of nature and you enter into civil society in order to better protect the rights you had when you were in the state of nature. So civil rights are not the same as natural rights, but civil rights are the positive law guarantees that exist to protect your pre-existing natural rights. And that's one important part of civil rights. But the other part of civil rights we discuss is that as a citizen, you have a right to access post-political goods that the state has chosen to create, though it is not obligated to create, such as roads, streets, parks, and schools. If the state chooses to provide public goods of this kind, post-political goods of this kind, then all citizens have a right of non-discriminatory access to these public goods. And for a summary of what the civil rights that were protected by the 14th Amendment, we turn to Ohio Republican Representative William Lawrence, a member of the House Judiciary Committee, who said this in support of the Civil Rights Act of 1866, describing the civil rights at what the Civil Rights Act of 1866 was trying to accomplish. Quote, "There are certain absolute rights which pertain to every citizen, which are inherent, and of which a state cannot constitutionally deprive him. Not only are these rights inherent and indestructible, but the means whereby they may be possessed and enjoyed are equally so. Every citizen, therefore, has the absolute right to live, the right of personal security, personal liberty, and the right to acquire and enjoy property. These are rights of citizenship. As necessary incidents of these rights, there are others, such as the right to make and enforce contracts, to purchase, hold, and enjoy property, and to share the benefit of laws for the security of person and property. All these rights that were described in that quote are what we would say today deeply rooted in the nation's tradition and history, as evidenced by the positive law of the Constitution and of the states, of, for example, the amendments to the Constitution that are enumerated, as well as the common law of the states in 1868, along with the rights that are enumerated in the Civil Rights Act of 1866. Now, some of these deeply rooted privileges or immunities are enumerated in the text of the Constitution, but others are not, like the fundamental right of parents to raise their own children, the right to preserve one's life, or the right to pursue a lawful occupation. These are all unenumerated rights. And if you think that the only constitutional rights you have are the ones that are enumerated, then you must also believe that you have no constitutional right to raise your own children or to preserve your own life. But the key question for constitutional interpreters is to identify what are the recognized in positive law privileges of citizenship, not what a judge or other decision maker thinks they ought to be. So what about the due process of law and the equal protection of the laws clauses? The due process of law clause is indeed about process, a judicial process to protect all persons, not just citizens, against the arbitrary exercise of power. First and foremost, the due process of law requires a reliable fact-finding procedure to assess the guilt or innocence of persons before they can be executed, jailed, or fined, thereby depriving them of their life, liberty, or property. But it requires more than this. The due process of law also requires that persons not be executed, jailed, or fined, except according to a law that is valid because it is within the just power or the competence of a legislature to enact. In addition to an opportunity to contest their guilt, the due process of law requires that all persons be able to contest whether a statute was within the just power of a legislature. This requires a judicial assessment of the substance of a statute to ensure that it is a valid law. Now, that's not the same as modern substantive due process, in which judges identify some substantive rights as fundamental and then protect these rights with heightened scrutiny while leaving all other liberties to rational basis review, or what is more accurately described as conceivable basis review. But the due process of law does require judges to examine the substance of a statute to ensure that it was within the legislative power. At the federal level, this means was within one of the enumerated powers of Congress. At the state level, it means within the general police power of the states. The Equal Protection of the Laws Clause guarantees state protection of civil rights against attacks by both public and private actors and prohibits state discrimination with respect to civil rights. This clause imposes an affirmative duty on the states to protect the fundamental rights of all persons within its jurisdiction. Finally, Section 5 empowers Congress to step in to protect the rights of citizens and people where states systematically invade them or fail to secure them. When the federal judiciary is not competent to impose remedies on the states for their failures of protection, Congress can provide federal remedies as an alternative, as the Reconstruction Congress did several times. The evidence of original meaning we present challenges the beliefs of both progressives and conservatives. The most significant misinterpretation of the 14th Amendment lies in the belief that its Privileges or Immunities Clause is an impenetrable inkblot, to use Robert Bork's colorful phrase. Conservatives like Bork fear that a judicial recognition of this clause would open a Pandora's box of judicially invented rights that would unduly interfere with the lawmaking powers of state legislatures. Due to these concerns, in the 2010 gun rights case of McDonald versus City of Chicago, 4 of the 5 conservative justices, including Justice Scalia, refused to restore the original meaning of the Privileges or Immunities Clause to its rightful place. Only Justice Thomas was willing to do so. As a result, the clause has continued to be written out of the Constitution by the courts. But if the meaning of the due process of law and equal protection of the laws clauses has been expanded beyond their original meaning to make up for its absence, the absence of the Privileges or Immunities Clause, then why should we care? After all, in McDonald, didn't the 4 other conservative justices reach the right originalist result using the modern doctrine of substantive due process? So why isn't this a case of no harm, no foul? In the book, Evan and I maintain that adopting the original meaning of the 14th Amendment as a whole would not lead to results that differ radically from those the current doctrine would produce. Despite being non-originalist in method, the Supreme Court's interpretations of the due process of law and equal protection of the laws clauses have often converged on results that are consistent with the original meaning of Section 1 as a whole, just as if the Privileges or Immunities Clause was still operative. Now, if we're correct in this claim, then restoring the original meaning of the whole of Section 1, including the Privileges or Immunities Clause, is not as radical as it sounds, because it would reach many of the same results now reached by existing doctrines. But we insist that adhering to the original meaning of the 14th Amendment would be better still. Restoring the meaning of all 3 clauses, together with that of Congress's Section 5 powers, would result in significant improvements in our constitutional practice. 2 big departures from current doctrine would be, first, better judicial protection of economic liberties from arbitrary regulations by state legislatures, something that became and has become a pressing issue during the COVID epidemic, when economic liberty has been left entirely unprotected by the courts from arbitrary restrictions. Second would be the judicial recognition of an affirmative duty on the part of states to provide protection against violence by private actors. We expect the former of these departures would be welcomed by some on the political right. The latter would be welcomed by some on the political left. Yet another important benefit of restoring the original meaning of these clauses would be to dispel the cloud of illegitimacy that currently enshrouds some important doctrines. This would include, for example, the application of the first 8 amendments to the states via the wrong clause of the 14th Amendment. It would also include the current protection of certain unenumerated personal liberties, now classified as fundamental rights by existing doctrine. Both the so-called incorporation doctrine and the protection of any unenumerated rights remain under a cloud in the minds of many conservatives. By itself, achieving this legitimation would be a very big deal for many on both the political right and left. Finally, getting the original meaning of the 14th Amendment right is important because it would help legitimate originalism itself. Non-originalists have trotted out a litany of entrenched constitutional doctrines that most Americans celebrate but are said to be contrary to the original meaning of the text. These critics then urge that this conflict between popular moral intuitions and originalism be resolved against originalism. If, however, originalism not only fits but morally justifies popular doctrines, there's no conflict to resolve. But having identified what the book covers, let me close by stipulating what it doesn't. We do not attempt to apply the letter and original spirit of the 14th Amendment to the most contentious, hot-button issues now confronting the courts. Nor will I do so in my remarks here today, nor during the question and answer period. Presenting all the evidence that would bear on each hot-button issue would take several more chapters, if not a separate book, on each topic. As important, Evan and I reject the tendency of people to judge the merits of an interpretive approach by whether it aligns with their preferred outcomes in hard cases. Tell us the results your theory reaches, they say, and we will tell you if we think your theory is valid. We think hard cases make bad theory. It's more important to reach a consensus about the original meaning of the 14th Amendment in general terms before debating how that meaning would lead to any particular result. Let me close these remarks with an observation on a somewhat different note. Those who still believe in the American experiment, with its written constitution, need a better narrative than one that begins and ends at the founding. We believe this book provides such a narrative, the narrative of the decades-long struggle after the founding, first against the evil of chattel slavery and then against the evil of white supremacy. This struggle resulted in the formation of a political party, the Republican Party, that amended our written constitution in fundamental ways, first by the 13th Amendment, then by the 14th Amendment, eventually by the 15th Amendment. Thanks to those who enshrined the 14th Amendment into its text, together with the 15th and 19th Amendments, which later made the right of suffrage a privilege of national citizenship, which it was not in 1868. Our Constitution is a far better Constitution than it was in 1789. It is this amended Constitution that today needs to be defended from strident and ill-informed attacks upon it. But defending the Constitution as amended first requires that one accurately interpret its letter and identify its spirit. That is the mission of our book. Thanks.
Thank you, Professor Barnett. That was quite wonderful. We can see you've had some practice with it. I'll kick it off. We have two wonderful questions from 1Ls. Obviously important thresholds question to this, or interesting question at the very least, given this whole conversation, asked by Maggie Roberts is, do you think there's any hope, essentially? Will the court ever revive the privileges or immunities clause in the way that you'd like to see it?
Well, the best opportunity it had to do that, Maddie, was the McDonald case in 2010, because the right to keep and bear arms was so overwhelmingly a privilege of citizenship in 1868 that it would not have affected the result at all to recognize it there. And I urge you to go and we discussed that in the book, but you should also go and listen to the oral argument when Alan Gura was defending this in front of the court and see the hard time that he was given by Justice Scalia, for example, for proposing returning to the original meaning. It's enlightening to watch this happen. So it didn't happen there. It could have happened in the Timms case, which recognized the right to be of excessive fines to be applicable to the states. That recently happened. And so we've lost our opportunity to use the Privilege Immunities Clause to accurately enforce enumerated rights against states, which is the easy cases, leaving only unenumerated rights, which makes it much less likely that the court is likely to open up that what they think is a Pandora's box. So I can't say that I'm optimistic, but I will say this: an absolute necessary prerequisite to restore the original meaning is for justices to have confidence that they know what the original meaning of the Privileges or Immunities Clause is. And there is good reason, I would say, why you could, on the one hand, know that the slaughterhouse cases are wrong. Almost every con law professor believes that, regardless of politics. But on the other hand, not knowing for sure what the right meaning of the Privilege Immunities Clause is. And so the solution to this is knowledge, like, for example, a book. I mean, there isn't all that many things a book can accomplish, but one of the things a book can accomplish is to present the justices and others with the evidence, hopefully fairly presented in a balanced way, not cherry-picked, and considering all the rival interpretations and why they don't really fit the evidence. The justices reading this book and growing confident that they actually think they do know what the meaning was is a necessary prerequisite to them doing something about it. So it's necessary, but it's not sufficient. We'll see what happens.
Great. And Wes Dodson asks a question, sort of probing how much work the Privileges or Immunities Clause will do, given your own, I assume, personal preferences. He asks if you could describe a right that might be well established as a matter of libertarian moral philosophy, but that would not be encompassed in the concept of ordered liberty that is not protected by the 14th Amendment.
That's a good one. Because I would like to be able to have one off the top of my head that I'm used to using in a situation like this. And at the moment, I don't have one. It depends, I think, on how specific you get, because in general, what the clause requires, what the due process of law requires, given the existence of the Privilege Immunities Clause, is a judicial assessment of whether a law is truly within the police power of the states. And the police power of the states is a power that states have to regulate liberty. So to the degree you believe in the regulation of liberty, the police power of the states is that power to regulate liberty. Now, it must be reasonably regulated. And so I can imagine there are many liberties, there are many restrictions on liberty that would be upheld that I might think should not be upheld as a libertarian, because they are good faith exercises of the police power. That is, they are good faith efforts to achieve the health and safety of the general community, even though they might be wrong. And so to answer that question in the abstract is very difficult, because in the abstract, I think almost all natural rights are liberty rights. Natural rights are the rights that get protected as civil rights when we enter into civil society. So there really isn't much difference between what in the abstract somebody who believes as a libertarian would believe is a right. But when you actually come to regulate that right, there's going to be a lot of disagreement over whether a particular regulation of that right by the states is going to be within the police power or bad faith exercise of that power outside the police power. And an example of a bad faith law is a law that's ostensibly passed as a health and safety matter, but is actually done for some purpose that's not within the police power of the states. Like, for example, if it's a regulation of the right to keep and bear arms that is not being done, it's ostensibly being done because of public safety, but it's actually being done because the people that are deciding it, the people that pass the law, the people that are deciding upon the law, they just don't like that right. That would be an improper purpose for that amendment. Now, how do you detect whether a purpose is improper or not? That's when you need to look at fit. The fit between the means and the fit between the ends. The due process of law is there. Law clause is there to protect against arbitrary power, and arbitrary power is power that's insufficiently justified on the basis of reason. And the means have to be appropriate to an end, and the end has to be consistent with the privileges or immunities of citizens. I should say the end has to be consistent with a proper theory of the police power of the states, just as federal law, the end has to be within one of the enumerated powers of Congress.
So that question and answer brought to mind a question I had, which was basically, do you think Lochner should have been overruled? Even if you don't, I wonder what the limit to the economic liberty is that you believe is protected by the 14th Amendment under your interpretation of the Privileges or Immunities Clause.
Well, let me answer the second part first. The liberty that, by the time Lochner's decided, the Privileges or Immunities Clause is gone. Therefore, Lochner is being decided as a due process clause case. and the due process clause is being expanded. As in Lochner and other cases, and other cases that are still good law, like Pierce versus Society of Sisters and Meyer v. Nebraska. These were all Lochner era cases that are decided on the basis of liberty within the due process clause. They are all good law. They are the basis of the right of privacy that we have today, as well as other rights that we have today. I think what we say in the book is the way that the liberty and life, liberty, and property should better be considered is as I said in my talk, life is something that capital punishment takes away, liberty is something that incarceration takes away, and property is something that a fine or judgment takes away. So if those are one of the consequences you're looking at, then you require a process by which you see whether the taking away of those things is within the just power of the states. Now in Lochner, that doesn't change. The reformulation of what right is at stake doesn't change the analysis, because in Lochner, Joseph Lochner was imprisoned. He was incarcerated for failing to pay a fine that was imposed upon him for having his employee exceed the maximum hours law. Lochner was a test case set up in a cooperation between the employee and the employer to test the constitutionality of the New York statute. And Lochner went to jail because of this. Well, his liberty he was being deprived of liberty, and if he'd paid the fine, he'd be deprived of property. So we're still faced with the issue of how the case should be decided. But it's important to realize that it wouldn't be the liberty in the due process clause is not the liberty of contract. The liberty of contract is a background liberty that's reflected in the Civil Rights Act of 1866, the right to make and enforce contracts. It's recognized in the contracts clause as well. And so that's a background liberty. But that, like all liberties, that liberty can be reasonably regulated. So the question in Lochner is, was it being reasonably regulated, or was it instead being passed for what the court twice refers to as other motives? Now, they don't say what those other motives were, but they're suspecting there are other motives. So how did the court reach the conclusion that this was a law that was passed for other motives? It wasn't by examining the motives of the legislature. It wasn't by, for example, discussing the fact that this particular provision of the Bake Shop Act was parachuted into the Bake Shop Act at the behest of the bake shop unions. The Bake Shop Act was an overall regulation of the health and safety in the bake shops in New York and in New York City and elsewhere, in which conditions were actually pretty bad. And the court, I should say, implicitly in Lochner, upheld as constitutional the rest of the Bake Shop Act, which was an elaborate regulation of bake shops. And the reason we know what's in the Bake Shop Act is the provisions of it are reproduced in a footnote in the Lochner majority opinion. All of those regulations were upheld implicitly. They weren't challenged, but they were also implicitly okayed by the terrible, awful, evil Lochner court. There's only one provision that the court concluded 5-4 was passed due to other motives because of a lack of fit between means and a lack of demonstrated fit between means and a health and safety end. Now, when you ask me whether it was correctly decided, I mean, I like Lochner because I think the burden should be on the government to establish fit by the use of record evidence. If they are actually acting reasonably, presumably they're acting on the basis of evidence. They're not just acting on the basis of their arbitrary preferences, will, desires, imaginations, and they should be able to present it to the court, and they should be able to sustain some burden. If you believe, so that's what I like about the Lochner case. Now, you might disagree with the Lochner court's factual conclusion about whether there's an adequate fit between means and ends there. Justice Harlan did. Justice Harlan, in his dissenting opinion, argued for a presumption of constitutionality in which the benefit of the doubt went to the government, and the burden was on the challengers to demonstrate a lack of fit. But Justice Harlan was still believing, and he always believed, that there did need to be a demonstrated fit between means and ends. So in that case, the difference between Harlan and the majority is a matter of who bears the burden of proof. When I agreed to debate Akhil Amar about whether Lochner was correctly decided at the Federal Society Lawyers Convention a few years ago, he kind of flummoxed me a little bit because he chose to defend Harlan's dissenting opinion and repudiate Holmes's dissenting opinion. And that's a little harder for me to go after because it's really a matter of who bears the burden of proof in a realistic inquiry. The opinion that I strongly disagree with, which was Holmes is the only justice who held this opinion. None of the other two dissenting justices joined Harlan's opinion. They didn't join Holmes. Holmes's opinion eventually became the law in Williamson v. Lee Optical in 1955 in a Warren Court case. But Holmes essentially adopted the conceivable basis test. And as long as a reasonable person could conceivably have passed this for a conceivably good reason, that makes it constitutional. That is a completely formalist, non-realist approach to evaluating the means and ends, and essentially eliminates any inquiry into means and ends. That's the mistake. So whether you want to go the Peckham approach or you want to go the Harlan approach, that's something that's both within the inquiry, the spirit of the Constitution, in which you're trying to figure out, was this a good faith exercise of the police power to protect health and safety, or was it in fact passed for other motives that are beyond the power of the police? And the other motives they suspected, which they didn't say, was simply taking sides in a contest between organized labor, trade unions, and management or ownership. And so the legislature, the court thought, was just taking sides rather than protecting health and safety. I know that's a long answer, but hopefully it resonates with you. If you've read the Lochner case, hopefully everything I said strikes you as being a plausible reading of all three opinions in the Lochner case.
As long as we're talking about this, the scope and the limit of certain rights that you believe are protected by the amendment, you mentioned in that answer a right to privacy. And I'm curious, we all know that from Griswold and where it's gone from there. So what is a right to privacy? And
I don't have any opinion about. I don't advocate a right of privacy. I advocate liberty, not privacy. The reason why the right of privacy, I believe the reason why the term privacy was chosen by the Warren Court was because they were post-Williamson v. Lee Optical, they were post-New Deal, and they didn't want to recognize a right of liberty, because to recognize a right to liberty what was at stake was liberty would sound a lot like the Lochner era. In fact, the Lochner era really didn't have a bad name until Griswold versus Connecticut. During oral argument in the Griswold case, somebody asked whether this was whether the parties were returning to Lochner, and one of the justices, and now I think it was Justice Black, said, "Let's say Lochner. That was the case involving regulating the size of loaves of bread, wasn't it?" So, he was close. It was about bread. In his dissenting opinion, he actually gets the case right. But off the top of his head, he didn't really know what the Lochner case was. So it goes to show that the evilness of the Lochner case is really a post-Griswold phenomenon. And it was actually made into this bogeyman by people who were critical of Griswold, like, for example, Gerald Gunther at Stanford Law School in his famous casebook, which I had when I was a law student. So anyway, I don't put these things in terms of the right of privacy. I do think this is Griswold is a decision that could be justified on originalist grounds if the Privileges or Immunities Clause was restored, but it wouldn't be the outcome would be justified, but the reasoning, creating a right of privacy per se, is not the way you would go about doing it. You'd go about doing it and asking if this was a good faith health and safety law under the police power of the state, or was it not?
All right, now for an unrelated but really interesting question submitted by Jensen Stevens, who asks, if the original meaning of the Privileges or Immunities Clause were applied, would it change the scope of which substantive rights are held by non-citizens? And that question is based on the fact that the Due Process Clause applies to persons, and the Privileges or Immunities Clause applies to citizens.
Right. So this is thank you for that question. Every theory of the 14th Amendment needs to have an account of what is the difference between the coverage of the Privileges or Immunities Clause, which applies to citizens, and the coverage of the Due Process Clause and the Equal Protection of the Laws clauses that apply to all persons. If a theory doesn't account for why those two clauses are worded differently, then there's something wrong with that theory, or something insufficient about that theory. And we believe we've presented the best account of that difference in our book. And let me just talk about it in more abstract terms. The Due Process of Law Clause and the Equal Protection of Law Clause applying to all persons protects all persons in what you might call their natural rights. That is, they're all into civil society, and they, in return for being in civil society and obeying the laws of civil society, they have a protection, or accepting the laws of civil society, they get a protection of their natural rights. In the case of the due process of law, from having their life, liberty, or property arbitrarily taken from them by a law that is not sufficiently related to means to ends. And in the case of the Equal Protection of the Laws Clause, it means that the enforcement of the laws, no matter how well they look on the books, need to be done in an equal manner. Some people can't be deprived of the protection of the laws. And laws need to be enacted to provide the protection of the laws to all persons. The Privilege and Immunities Clause, the privilege and immunity to citizens of the United States includes all of those rights, includes all of those basic rights that are fundamental natural rights, but it also includes more. As I said in the beginning, it includes a right of non-discriminatory access to post-political goods that are provided by government, that government is not obligatory, they're not obligated to provide, but if they choose to provide, then all citizens are entitled to access to those privileges. That's like, there's an old American Express commercial before all of your time that advertised the American Express card that said membership has its privileges. Membership in a polity like the United States has its privileges. And these privileges are, for example, to access government schools. Now, there is no natural right to attend a government school because there's no government schools in the state of nature. But once government has chosen to do so, it's a fundamental right of Republican citizenship that nobody can be denied that right on an arbitrary fashion, in a discriminatory way. And in fact, the separate but equal doctrine that was upheld in Plessy versus Ferguson with respect to the railroads and eventually abandoned with respect to schools in Brown versus Board of Education, that doctrine is a concession. It's a concession to the principle that African Americans, free African Americans, do have a right to equal provision of a governmental, post-political government good, in this case, schools. The separate but equal doctrine is a constitutional construction purporting not to infringe upon that right, because you still get access to equal education or equal train cars. We believe that that reason why that discrimination is not justified as a correct construction of the equal protection of the laws or of the Privilege and Immunities Clause, the Privilege and Immunities Clause, is because its purpose, if you actually are realistic about it and not formalistic about it, was to subjugate African Americans. That's what the court blinked, ignored deliberately, knowingly in Plessy versus Ferguson, but Justice Harlan didn't. And that's why his dissenting opinion is so important, because he said, we know what the purpose is behind this. And that's an improper purpose. That's a purpose that is not an appropriate exercise of the police power. This is not really being done for health and safety. And their evaluation of whether it was being done for health and safety was confined to one paragraph, like 2 or 3 sentences, completely conclusory and completely formalistic.
In your talk, you mentioned that under your interpretation of the Privileges or Immunities Clause, the 14th Amendment does actually impose affirmative obligations on states to protect citizens from private violence. Could you tell us a bit more about that, what the ramifications of that would be if the Supreme Court came around to your understanding of the amendment?
Yes, this is one of the most interesting parts of our findings. And let me just back up and say something which might mean something to people or may not. It may be surprising to you. I have published several books, including the Restoring the Lost Constitution, in which I discussed the original meaning of the 14th Amendment. And in doing the research for this book, and Evan Bernick is the person who did the lion's share of the research for this book. In doing the research for this book, I came to modify my views, previously published views on each of the amendments. And so, especially in particular, the Privilege and Immunities Clause. And I can talk a little bit about how I changed what my view used to be and then what it became. But it was the evidence that drove this forward. And this also was a result of a collaboration between Evan Bernick and myself, which I think the evidence is pretty undeniable, and it caused me to change my mind. I was just drew a blank on the question you asked, because I was going to come back to, what's the question again?
The obligation it would impose on.
Yes, right. Okay. So this, I didn't have any real reason to question. Well, I did. I take it back. I did have reason to question the state action doctrine, but we actually, because I had already been persuaded by Chris Green's work on the state action doctrine. We went into the project thinking Chris Green was right, and then we discovered that evidence that suggests the Equal Protection Clause does more work than Chris thinks. So here's what it is. I mean, you have the state action doctrine, which you all learn, and I want you to know for purposes of your common law exam, there is a state action doctrine, and you must apply it, and it's not the right answer to not apply it. The state action doctrine properly applies to the Privileged Immunities Clause because it's about no state shall make or enforce any law. The state action properly applies to the Due Process Clause because it's about the state providing the due process of law. But the state action is inappropriately applied to the Equal Protection Clause because the failure of protection, that is state inaction, is a paradigm violation or breach of the duty of protection that was put into the Constitution by the Equal Protection Clause. And this has this idea that there's a duty of protection. We explain the long-standing history and development of this idea of a duty of protection that took place in anti-slavery thought in the early 19th century and in natural rights thinking in the early 19th century. So there is a duty of protection. And if the state fails to protect, state inaction can be a violation of the Equal Protection Clause. So this is something that we insist upon. Now the question is, what happens if that happens? What is the remedy for that? One of the reasons why the courts and why I think just conservative justices would cling to the state action doctrine kind of no matter what is because what they're afraid of, and if you think about the DeShaney case, if you don't know what the DeShaney case is, we talk a lot about it in the book. If you do know what the DeShaney case is, then you'll know that I'm referring to something like that. It was a very tragic case of the state failing to protect a young child from being abused and eventually killed by his father. What they're afraid of, and I think, and we say in the book, justifiably so, is that the creation of private causes of action for the failure of protection in which individual plaintiffs can go to court and sue for damages is really a recipe to completely swamp state governments in the need to pay out jury verdicts and large awards and settlements to the point where all this tax money is not going to be used for the purposes for which it was collected, which is the provision of the health and safety of the general public. So we understand why the court would be reluctant to abandon the state action doctrine, which completely cuts off that possibility. However, what the Republicans did during Reconstruction, when they were faced with a failure of protection, is not to require that states did this or that, but is to create a federal alternative cause of action. The Civil Rights Act of 1866 itself created a bypass statute so that if, for example, an African American was tried in a jurisdiction where the jury pool was excluded African Americans from the jury pool, that African American had a right to remove that case from state court and go to federal court where they could get a trial by a jury that was not racially exclusionary. This was upheld by the Supreme Court in one of the rare examples of the Reconstruction Court of protecting civil rights, and that was in Strouder versus West Virginia. Strouder versus West Virginia is studied as an Equal Protection Clause case because it was a violation of equal protection to deprive somebody of a trial in which the jury pool was tainted in this way. What gets cut out of the case book, even in my case book until I started doing the work on this book, is the fact that what was at issue in Strouder was a federal statute, the constitutionality of a federal statute removing the case from state court to federal court. That's also what the Civil Rights Act of 1875 did, which was declared unconstitutional in the civil rights cases. It didn't force states to bar discrimination. It said you can go to federal court if the states fail to protect your rights to access public accommodations. It was a public accommodations law. That's a very important finding. And here is, for those of you who know what City of Bernie case is, and which is a Section 5 case, we don't dispute the correctness of City of Bernie. That is, we don't dispute the idea that Section 5 powers of Congress must be congruent and proportional to the scope of the rights that are protected in Section 1. We believe that's true. But we believe that when the scope of the rights in Section 1 have been overly narrowly construed because of a fear of the judiciary being unable to craft remedies, because it's beyond the judicial competence to craft remedies, then the judiciary, if they were doing their job, should declare this is an under-enforced constitutional norm. We can't enforce it, but Congress can. Congress can create remedies that the courts cannot create. Congress create bypass statutes that the courts cannot create. And so, when the court artificially restricts Section 1 because of concerns about its own judicial powers, that's going to have, under Bernie, it's going to have the effect of restricting Congress as well. And so we think a more realistic approach, a more accurate approach to Section 1 will automatically result in a more accurate reading of Section 5. So, for example, if there's a problem in the City of Bernie case itself, which had to do with free exercise of religion, when Congress is attempting to reverse the Smith case, and it reimposed the Sherbert case, which is strict scrutiny for the failure to make a religious accommodation. If you have a problem with Bernie, it might be because you have a problem with Smith. That Smith was not an originalist case. Smith was an opinion by Justice Scalia, which was concerned about judicial competence in being able to craft judicially created exceptions to rules of general application. Something that it turned out, because the court upheld federal RFRA, that courts were capable of doing in federal cases, but not capable of doing in state cases, which is odd, because if they're not capable of doing it, you would think they would be not capable of doing it in either event. But nevertheless, the problem here with Bernie would not be actually Bernie itself, but Smith and how narrowly construed. That's something we talk a lot about in the book, and it's one of the interesting findings that really was new to me when we did this project.
So we're coming up on the end of time. I'll try to squeeze in one of the two great questions we have submitted. It also relates to a question I had. Isaiah McKinney asks, and I think you were getting at this a bit towards the end of that answer, what you think the biggest objection to reviving the Privileges or Immunities Clause is. And I was going to ask, we all know that the Supreme Court can and does get things wrong, but what do you think the strongest argument that in favor of current Privileges or Immunities Clause jurisprudence is as an interpretive?
Well, I'll just tell you the thing that I think bothers the left and the right. The left side of the court and the right side of the court the most is I think the right side of the court is afraid of legitimating the protection of unenumerated rights. They start with the position that all unenumerated rights are illegitimate, but due to stare decisis and whatever other considerations they take into effect, they have crafted a doctrine, the substantive due process, that limits the scope of unenumerated rights. And they don't want any more. They don't want any greater ones. So they're trying to hold the line because they think no unenumerated rights should be protected. And the problem for them of recognizing Privilege and Immunities Clause is it legitimates the protection of some unenumerated rights. And they don't like that. It turns out the standard we have for recognizing enumerated rights, we take on board the Glucksberg standard that the conservatives use to do substantive due process that is deeply rooted in the nation's tradition and history. We bring that on board and we use it to the Privilege and Immunities Clause, so judges could say, look, we can use the same test we do to limit substantive due process. We can use this over in the Privilege and Immunities Clause as well, but we need to do so better than they have been doing up till now. The problem with the left side of the court is, I think I already indicated that part of the liberties that would be protected by the Civil Rights Act of 1866 were the economic liberties to make and enforce contracts, to sue and to hold and enjoy real and personal property, what we today call economic liberty, and is not protected. The left side of the court is not looking to do that. So that would be what they would fear from reviving the Privilege and Immunities Clause. And then there are other fears. I mean, if you listen to Justice Ginsburg's questioning of Alan Gura, there's a fear that the original meaning of the 14th Amendment excluded women, for example, if you look at the Bradwell case. And so she said, were not protected by the 14th Amendment. We believe this is false. We believe Bradwell decided the day after Slaughterhouse was wrongly decided that Chief Justice Chase, when he dissented in Bradwell, was correct to do so. That was an 8-1 decision. And so part of the problem that the left side of the court has is they have a misconception of what reviving the original meaning of the 14th Amendment would actually entail. And we believe our book goes a long way to disabusing them of that misunderstanding.
Well, great, right on time. We're wrapping up, and we really want to thank you so much for joining us, Professor Barnett. For those of you who don't know, we were speaking before the event. He has his 70th birthday coming up, and he'll be spending it somewhere lovely. I forget where, on a catamaran, and
off the Virgin Islands, off the U.S. Virgin Islands, so we don't have to leave the country and try to get back into the country. And who knows if you can.
Well, the Texas Federalist Society wishes you a good time there, and thanks so much. We hope to hear that some of you out there listening will be attending the Originalism Summer Seminar this summer, and also please, if you can, join us next Thursday afternoon on campus for a debate about qualified immunity. Thanks all. Have a good night.